Mr. Knox.
Thank you, my lady. My lord. If I deal with my first point, the words of clause 3 are clear and unambiguous. I don't want to labour this point, but can I take you to clause 3 in the core bundle? In the supplementary bundle at page 5. Begins under the heading, I submit not insignificantly, sale of Valsa or Vesa real estate assets. And then at 3.1, the purchaser agrees as soon as possible following the effective date, and that, I think, was the 31st of October, so shortly after.
Assuming your first point actually, though, falls to the ground given clause 1.2.2.
Mm-hmm. Yes, I think that is a good point, my lord. So I have to withdraw my first, not particularly strong point anyway. Perhaps I'm better off not having. Anyway, but in any event, the purchaser agrees as soon as possible, following the effective date, 31st of October, that it will use its reasonable endeavours to identify third-party buyers for any and all of the real estate assets owned by Valsa or Vesa. They are specifically defined as real estate assets at the best saleable price. I submit there is no ambiguity about that whatsoever. What we have to do is to look for or identify buyers for properties. We have to use reasonable endeavours. I do emphasise this. We're not necessarily obliged to sell, because of course we might not find any decent buyers, but we're certainly obliged to look. And no doubt if we look and find a decent buyer and the profit is made, then of course the profit share works. But I submit that's clear. Then 3.2.
But you'd also say, presumably in 3.1, that it's real estate assets owned by Valsa or Vesa.
Absolutely, owned by. Owned by is the operative phrase. 3.2, if after the effective date any real estate asset is sold to an unconnected party, the purchaser shall pay the net profit attributable to any such sold real estate asset in the following proportion. So again, it sort of laboriously repeats the notion of a real estate asset that's been sold. And then you have the formula in 3.21 and 3.22, referring to the net profit, which is defined in 3.3. For the purposes of clause 2, the net profit attributable to a sold real estate asset shall be calculated by deducting from the price paid for the relevant real estate asset by the third party the following items. And just pausing there, that again is presupposing a sale of an individual property. Of course, it may be lots of individual properties get sold to a particular purchaser, in which case the formula applies in any event. But then you'll see how the formula is to work. Bank facilities or other financing secured on or utilised in relation to such real estate asset, whether by mortgage, charge or similar security. Again, it is simply by reference to the property itself. And so what you do is you look at the mortgage on the property. There's no question there of looking at mortgages on, let's say, or charges on Valsa's shares or Soto's shares. And then 3.32, any sales commission relating to the relevant real estate asset. Again, relevant real estate asset. Then 3.33, any taxes relating to or arising from the sale of the relevant real estate asset, or relating to the distribution of the net profit, any legal, accounting and other professional fees incurred in connection with the relevant real estate asset. 3.3.5, and I do particularly emphasise this, any direct costs associated with the development or enhancement of the relevant real estate asset, including but not limited to any infrastructure costs. Again, this couldn't be clearer. And of course, 3.3.5 is obviously has to be read, I'll come to this later, in the context in which this agreement was made, when it specifically envisaged there will be developments of individual properties. So all this makes perfect sense in the context of individual sales of individual properties. It makes no sense in my submission in the context of share sales of Valsa and Vesa, but I do emphasise there's even less sense in the context of a share sale of Soto itself, which was going to have, may well have a much more complicated structure than, let us say, Valsa and Vesa.
But it has to make sense in relation to a share sale in the circumstance set out at the end of 3.7.
My lord, I shall come to that in a moment, if I
Okay.
may. 3.4.
Incidentally, just
Yes.
we passed over it, but it's quick. In 3.2.2, that's a typo for 6.2 is a typo for 6.3, I think. But
Yes.
it's right that the profit share was, if there was amounts outstanding under the loan agreements, the loan facilities, that there would be a right of set-off.
Yes.
So the way it worked is that you could recoup yourself, that you wouldn't actually have to pay a profit share unless or until the loans outstanding to JOP had been repaid, I think.
Yes. In the event that didn't happen.
No, but that's the way that's the structure.
That's the way it's meant to work, yes. We would be entitled, effectively, until he's repaid his debts, we'd be entitled to withhold that relevant part of the profit share.
And he would want to discharge his indebtedness.
Yes.
Okay.
My lady, my lord, 3.4, net profit shall be paid by the purchaser, cash and so forth, by each of the purchaser and JOP, to accounts nominated by the purchaser and JOP, within 30 days of Valser or Vesser receiving in clear funds the full purchase price relating to the sale of each relevant real estate asset. And again, that's saying one thing only, quite obviously. 3.5 I can pass over. 3.6 is just the transferability of the rights. And then 3.7, my lady and my lords, I'll come to that in a moment. And then 3.8, JOP shall be punctually notified in writing of any real estate asset transfer, and he shall be duly informed of the details of each specific transaction. Now, I submit it is absolutely plain from that that this is talking about and envisaging simply a profit share in relation to sales of properties which yield a profit. That the draftsman is deliberately limiting these provisions to a sale of underlying assets, properties, is confirmed by clause 5. The draftsman is more than aware of the difference between underlying assets and a sale of assets and a sale of shares. And you see that, page 8, subject to clauses 5.5 and so on. If after the date of this agreement the purchaser, 1, sells all of its shares in Campo, or 2, through Campo sells all of its shares in Valderrama, or 3, through Valderrama 07, sells the Castellar development as an asset sale to a third party, then for a sum of over 16 million, then JOP will be entitled to a profit share. So the draftsman is plainly conscious of the difference between a share sale and an asset sale. And you can see that is repeated, I think I'm right in saying, in 5.4, the avoidance of doubt, and it repeats the 3 possibilities. And then 5.3.1, again, the 3 possible ways of making a transfer are repeated.
Do you make a point that at the last part of 5.1, after the bullet points, adopts a formula which could apply both to an asset sale and a sale of shares?
Sorry, did you mention 4.1?
5.1.
Yes, absolutely. It can be either.
It just says net of all fees, costs and expenses associated with the sale, and any development costs, presumably which is about a share sale or of the Castellar development.
Yes. It's making express provision for different ways of selling and envisaging a profit share in each of those 3 ways of selling.
What are development costs of a share there?
Well, it may be, no doubt it is loose language, but you would presumably say, well, if the shares are sold, you'll have to take into account, or you'll be entitled to take into account, the development costs of those sales in connection incurred on the property.
I see.
Presumably that's what it's envisaging. And
It's not crystal clear, is it?
it's not.
No.
I mean, I understand, picking that point up, I understand that Valderrama 707 might incur costs of, in relation to the Castellar development, which is an asset. But as Laura said, it's slightly more curious to understand what what Campo might incur. But Campo presumably would still incur fees, costs and expenses associated with the sale.
Yes.
So it just may be that
The development costs might be limited to Valderrama or the development itself.
yes, or Valderrama's development of the development itself.
Yeah.
And they could, of course, in the case, and they would relate, no doubt, to things such as planning, permissions and actual development of the golf course. But I submit that even if there are potential implicities in this, the basic point is that the draftsman is plainly aware of the difference between different types of sale. And you have that in 5.4 as well. Which is picking up on the possibility of a transfer of the shares, Campo shares, Valderrama 07 shares, or the development itself. And then 5.5, you have the same point again. I'll come back to this clause in a different context later, but I submitted as, and then 5.8, you get the same point. And 5.9. So all the way through, essentially all the way through clause 5, the draftsman is conscious of the need to include a sale of Campo and indeed of Valderrama 07 as part of the profit share arrangement. And I submit it is unthinkable that he's remembered to do that in relation to clause 5 and the sale of Campo or its assets or the Valderrama 07 shares, but he has for some reason omitted to do that in relation to clause 3. It makes no sense at all. And I submit the starting point must be it is deliberate that he has limited clause 3 in the way that he has. There's no basis for reading the real estate assets as meaning anything other than what clause 3 says. If I may now just go to clause 4. Again, here you see page 7. This deals with trademarks. And this again is simply providing for sale of trademarks, a Valderrama trademark. Or indeed a Valderrama 07 trademark. Now, Valderrama 07 trademark wouldn't be relevant to this case, but a Valset and Besser trademark would be relevant. But it is simply envisaging all the way through a profit share arrangement in the event of a sale of the trademark. That you get from 4.1, 4.2, which is obviously applicable to a sale of a trademark. It's not easy to see why it should be so limited if one is looking at the sale of Soto, for instance. The various deductions that are applicable. And then in particular clause 4.3. The net profit calculated pursuant to clause 4.2 shall be paid by Valser or Vesser as appropriate. So it's obviously envisaged that this is going to be a sale by Valser or Vesser, and the purchaser shall procure that such payments are made. So, in other words, that says MGI has to procure that such payments are made to Valser or Vesser in cash and so forth. And then 4.4, you have a long stop date in relation to this obligation to pay 9% of profit. 4.5, benefit is transferable to relatives of Mr. Ortiz-Patino. And 4.6, you have an equivalent to 3.7, albeit with a difference in slight difference in wording. Again, the notion that the draftsman is not conscious of the difference between share sales and property sales is inconsistent with the Putter loan, which is part of the PSA, and you find that at page 15. This is a loan facility to be granted by the respondent. Important point for the moment is clause 1 provides for a £450,000 loan and so forth. But then, page 16, clause 3.1, the additional loan will be made available only on condition that, for a certain date, we have not sold our shares in Campo to a third party, or 2, Campo Alto has not sold its shares to a third party, and VO7 has not sold its shares, assets to a third party. So, once again, the draftsman is specifically dealing with sales, different types of sale, and making provision for specific types of sale. So, I submit that on the face of it, and I'll come to 3.7 in a moment, on the face of it and subject to 3.7, there is no basis at all for construing the provisions of clause 3 as covering share sales. There is therefore no ambiguity whatsoever. Question then is, well, what about clause 3.7? Does that give rise to a relevant ambiguity? And I say no. And if I can take you to 3.7. The first point, my lords, you've read this before. If I can just ask you to look at it again, if you so wish.
Just to be clear, though, I mean, simply saying something is not ambiguous, that's not an answer to a case of absurdity, is it?
Well,
sorry, I put that as a question which you'll have to answer, I think.
All I would say is, in Arnold, the service charge on the proper construction, as the Supreme Court held, of the relevant agreement had come for a holiday chalet, had come to £550,000 a year. And Lord Calmworth, who dissented, said this isn't just uncommercial, it's crazy.
Yes,
I think that was pretty well his word.
Okay, but all right. Well, I thought last time I looked that if the words are clear, but nevertheless the court reaches a conclusion that that cannot be what the parties intended because it produces a result that is absurd. That the court searches for another answer to what they must have meant, because the alternative is to assume that the parties reached an absurd agreement, which is not something they could have intended. But it is a very, very high bar.
Ah, well, yes.
I mean, don't get me wrong, it's a very high bar, but just simply saying those words are clear and unambiguous is not an end of the inquiry, is it?
I think in Arnold, Lord Neuberger, he does deal with this point in his 7 principles, and I think he says maybe very exceptionally one might find the words lead to such a strange result. But in my submission, the trouble is, I speak from the bar rather than from the bench. The lawyers often say something's absurd, when it just means it doesn't make all that much sense. Absurdity is a very high bar. Maybe I'll have to take you in a moment.
Okay, well, we just need to understand, but I was just trying to pick you up, because if what you're saying is that our inquiry begins and ends with words which are unambiguous, then that's, I understand the submission, but I just don't know whether it's consistent with some of the authorities on the point in time at which the court can say, but if the result is nevertheless so absurd, we understand it's just not what the parties could have meant. Something has gone wrong with the agreement, I think is the expression. And then, then you're into a different set of authorities,
yes,
in some other areas. And speaking for myself, I wouldn't mind some reminder of where the law's got to on that.
Yes, well, can I just for a moment, just to kind of go, I'm quite happy to, I think, to take you to that right now, actually, because I think, before I get to clause 3.7, I think the main authority is, I think, is Arnold in Britain, because that was the case where there was the most absurd result that was upheld, with Lord Calmworth dissenting.
I think you were probably referring to paragraph 17 of Lord
Yes.
Greenbanker's judgment, where he says reliance placed in some cases on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language. And then the exercise of interpreting a provision involves identifying what the parties meant through the eyes of the reasonable reader, and save perhaps in very unusual case. I think that's what you were.
I think that's what I had in mind somewhere.
That the meaning is most obviously to be gleaned from the language of the provisions.
So I suppose one might say never say never. But the bar is very high, as indeed in my submission is well demonstrated by Arnold of Britain. It was a 4-1 judgment. When one reads Lord Carnware's judgment, you think, I've never read such a sort of an insanely bad deal from the point of view of the tenant, or who was subject to service charge. But nonetheless, the Supreme Court said, well, we can't see any way around the words. And the problem was in that case, I think broadly speaking, there was a provision for the service charge, which had been agreed back in the 90s, I think, for the service charge to go up 10% a year. Full stop. Not up to 10% a year, which is what the defendant tried to argue. The Supreme Court said, no, it doesn't say up to 10% a year, it says 10% a year. And I'm afraid you've agreed that this should be compounded. I'm afraid with compounding, you're now liable for £550,000 just for a holiday chalet. It's more, and that, the reason I emphasise that, my lady, my lords, is that, if ever there was something which is, one would say, can't be true. And the way Lord Carnware put it, it's crazy. I think that was his word. Not just on commercials. But the Supreme Court held, you've just got to give effect to the words the parties have used. And the problem in that case, there wasn't any evidence, broadly speaking, of the context. And so the court was simply being asked to look at the words cold, without any real context. And that's the point they made. And they said, looking at the words cold and with no context, we have to give them effect. So, I note my Lord Justice Snowden reading into the case. I'm happy to wait or carry on.
I'm just trying to find the. I think I'm familiar with the passage you've just been looking at. I'm just trying to see whether there's any notes in the extract from Lewison of to support the sort of or try and bridge the gap between the authorities that say where the words of the contract, though on their face clear and unambiguous, lead to a result which flouts business common sense, or which is absurd, they must yield, I think is the old sort of formulation. And I just wanted to remember where we got to on this.
I want to ask you to look at Britvic, which is a pensions case.
Before you do that,
Yes.
though, paragraph 20 of Arnold and Britain
Yes.
is of some assistance, I think, with that. Fourthly, while commercial common sense is a very important factor to take into account when interpreting a contract, a court should be very slow to reject the natural meaning of a provision as correct, simply because it appears to be a very imprudent term for one of the parties to have agreed, even ignoring benefit or wisdom of hindsight.
And the court should then not try to rewrite an agreement.
I'm sorry, you were taking us to Britvic. Where do we find that?
Yes, that begins.
6.
It's a pensions case. It begins at page. The headnote is page 146. But in this case, I think the question was whether, on the proper construction of the trust of the relevant agreement, there was the employer had a power to reduce the rate of an increase in inflation or not, and it all depended on how you read a particular set of words, because it was able, the employer could choose the RPI or another rate, or any other rate. The argument went on behalf of the pensioners, the fact that, any other rate must be any other higher rate, and the judge at first instance accepted that. But then the Court of Appeal said, no, that's not right, you've got to look at the words. No doubt this might be rather harsh, no doubt this, that and the other. The words, or any other rate, allow the employer to choose a lower rate. That might be a bit unfair, jolly tough luck and so forth. The words were clear and unambiguous. And I think you get the relevant passage is at, begins, I think I'm right in saying, paragraph 22. sorry, paragraph 24, I think is where there's a citation from Lord Hodge's judgment in Bernardo's. And then I'm just looking, I seem to have got a bad reference. But I think maybe it starts at paragraph 29, or paragraph 28. If I can just ask you to read paragraphs 28 to 32, you'll see how the Court of Appeal and the Master of the Rolls approach this. Beginning with paragraph 33. And what I submit one gets out of that is, first of all, paragraph 30, considerable weight must be accorded to the fact the drafter has used unambiguous words. Point. Paragraph 31, not a case where there's been sloppy or unclear drafting. It's been done by professionals. I submit that again applies here. Paragraph 32, I submit importantly, the Master of the Rolls says, I can quite see that there may have been a mistake. That's not enough if there may. You've got to say there has to have been a mistake, not just there may have been a mistake. And then, paragraph 33, the fourth point, I emphasise this again. Moreover, the process on corrective construction adopted in the alternative by the judge is only normally adopted where there really is an obvious mistake on the face of the document. And I submit that is the true principle. The difficulty here is, what is the obvious mistake? If one's just looking at it as a matter of language, where's the obvious mistake? It's far from obvious there's a mistake. It seems to be entirely deliberate. That's, say, the limitation to a profit share in the event of sales of properties. That doesn't look like a mistake. It's not just, but most of these cases I might have just tend to be on a phrase or two in a contract. This is a whole raft of provisions which all proceed on one premise. And I submit there's no basis to answer your question, my lord. Maybe you can, where the mistake is obvious. High bar, put another way.
There are some obvious mistakes in this document. For example, just to pick up the last one I pointed out, for 3.2.2, it says subject to the right of set-off contained in clause 6.2.
Yes.
That's an obvious mistake. It should say clause 6.3.
Yes.
So even though that is clear and unambiguous, it's obviously wrong.
Yes.
So you interpret it to mean 6.3.
Exactly, I accept that.
Right. So that's an example of corrective interpretation to produce a result that the parties must plainly have intended. You can see that from the document. It's the only clause that contains a set-off.
Also, as my lord, if I may interrupt, that's because the document itself requires one to do that. It's the only way one can actually give sense to the document. Otherwise, the document is senseless. Right. On that point.
There's another possibility, which is that you, and we see this in a number of the cases, where there's an error which isn't as clear as that on the face of the document. It's usually an omission,
yes,
where the result is one that is so absurd the parties could not have intended it to be the case.
Yes.
And in that unusual high bar,
Yes.
whatever you fell's case, the words may be unambiguous in the sense that there just usually isn't anything there,
Yes.
but you can interpret the contract so as to cure the error that you identify, but you have to be very clear about what the error is, which is what this case of
Yes.
interpretation is about.
Yes.
Now,
And it has to be clear from the rest of the document that there is a mistake, as opposed to may be a mistake.
yeah,
One just looks at the rest of it and says, well, that they can't have meant what they said there. It just doesn't fit because it's inconsistent. I mean, what one's really doing is correcting an inconsistency.
well, it's either inconsistent or else without it, the document just makes no
Sense.
sense to any normal person, business person, or otherwise looking at it.
Yes.
But and the question I'm just searching for is whether that is the level which we need to get to, you say, to adopt the approach that the appellants wish us to adopt, or whether there's some lesser standard. I think you say there is no lesser standard, but it is at least an exception to your bald point, which is ambiguous. Clear and unambiguous. That's an end of the inquiry.
And I think I'm right in saying, from recollection, Rainy Sky, I think it's paragraph 18, Lord Clark makes the point. If the contract the language is unambiguous, then you've just got to get back to it.
Yes, but the trouble, I think there has been a little bit of a retreat from that in very limited circumstances, of which
Yes.
I'm just trying to probe to see whether this case, for example, is one where the language may be clear, and although Lord Justice Nugent said
Yes.
you don't get into corrective interpretation unless there's ambiguity, and I'm not sure that's...
Not, but that may not be right, because in the light of, I think actually in the light of Rainy Sky. But I would submit that one's looking, first of all, at something that's clear, and it's clear there has been a mistake. And generally what you're doing is filling in or correcting something to make it consistent with the rest of the document, or at least so that the rest of the document, so it's consistent with the sense of the rest of the document. But the difficulty in this case for the appellant in my submission is this is a whole raft of clauses, and I'll come to 3.7, but apart from 3.7, it could not be clearer. I mean, there are, why on earth, what draftsman under the sun intending to say that this is to cover share sales would have drafted clause 3 in the way he has. But in particular, in relation to sales of shares by SOTO, which is what we're here talking about, it just doesn't fit at all. I mean, you could possibly, I could see maybe, I don't accept, but it might be, you'd say, well, if Balser and Vesser are simply nothing other than, so to speak, conduits for the underlying properties, and so that their value is entirely in the underlying properties, query whether their argument might run. But it can't run in relation to SOTO, which is a company with shares, which owns shares and has all sorts of liabilities. It's going to be carrying on business. It can't be well, what is to happen, for instance, if money is invested into SOTO, generally, and so forth. There's absolutely nothing in clause 3 which I submit can possibly fit a sale of SOTO.
And the points that you were just exploring in relation to mistake, etc., and the circumstances in which you then fill in the gap, I think are dealt with at paragraph 31 of Britvic by
Yes.
Master of the Rolls.
Yes. I'm grateful, my lady. I'm sorry.
No, that's fine.
I did have other, I think there's also a short citation which is in our skeleton argument from Lord Justice Coulson as well. I mean, I do accept that, I think actually one can pick it up, paragraph 56 to 60, where he considers the authorities. Again, he adopts the very unusual case. Yes. And paragraph 57 in particular, in the absence of ambiguity, it should be unnecessary to consider those arguments which are conventionally parasitic upon ambiguity. commercial common sense, and so forth.
Although he does then go on to say the court must consider the possibility something had gone wrong with the language.
Exactly.
I mean,
well, I accept that. The problem here is, don't want to sound too pedantic, something's gone wrong with the language, as opposed to a whole raft of things have gone wrong with the language. That's the problem we have here. This isn't just one clause that's completely wrong on the face of logical construction. It's something on the face of it is the main part of the document, indeed the governing part of the document, and repeatedly so. So I submit that is the difference between, I mean, generally speaking, of course, one would have rectification if you wanted to have what you might call a big, to correct the contract where something big has gone wrong. But I respectfully submit that the corrective interpretation applies only when it's obvious, and the correction that has to be made is almost like an implied term test. It's obvious. The contract doesn't work otherwise.
well, as I've just given you an example in 3.2.2.
Yeah, exactly.
You know, the words are clear and unambiguous. There's clause 6.2. Nothing could be clearer.
Yeah.
But it's plainly wrong.
Yeah. Well, that's I say that is the sort of common sense thing you adopt corrections to. As indeed, I think I might be wrong in saying this, but Manor Investments was, so to speak, the progenitor of all these cases. Something had obviously gone wrong because they had I think it was the tenant giving a break clause had effectively terminated, purported to terminate it on a day short, which the minority in the House of Lords said, bad luck, you just haven't served the right notice. And then Lord Hoffman gave a long speech explaining, well, that can't matter, because no one could have been under a misapprehension as to what this meant. Again, what he was correcting was small mistakes rather than big mistakes, because you can do that. I go to clause 3.7, page 6 of the supplementary bundle. Now, the first point I take is a fairly simple, obvious point. It applies only to a reorganisation, and that's clear from the beginning. No amount shall be payable in accordance with this clause 3 in the event that the purchaser reorganises the purchaser group, so that any real estate asset is transferred within the purchaser group or to any company, and so forth. But the whole of it is premised on there being a reorganisation and eventually either an asset transfer or a transfer of the shares in the company, to which the property is transferred in the reorganisation. That's the only event in which it applies. And in some ways, as I suggest, the judge got this right. Far from helping the appellant, this actually damages the appellant, because it does show, yet again, that the draftsman is conscious of the distinction between asset transfers and share transfers. But anyway, I say it applies only to reorganisation. Secondly, I say the judge is obviously right, so far as it matters, in what he says about the last few words of the penultimate sentence and the last sentence. The last few words are, taking the second sentence, if, however, following any such reorganisation, any real estate asset is subsequently transferred to a third-party buyer, the provisions of this clause shall apply, and JOP or assignees shall be entitled to any amounts payable in accordance with this clause 3.7. Now, that's obviously a mistake, because 3.7 doesn't provide for any payment itself. Then it continues for the purpose of this clause. Now, the judge was on to this point, because when you compare it's a boilerplate clause. When you compare 3.7 with, I think it's 4.3, is it 4.4? 4.6. You can see what ought to have happened, and this makes sense. If, however, following any such reorganisation, any trademark is subsequently transferred to a third-party buyer, the provisions of this clause shall apply, and JOP or his assignees shall be entitled to any amounts payable in accordance with this clause, that would mean clause 4, for the purpose of this clause 4.6 transfers. And I submit that that makes sense, and that's obviously what 3.7 should have said. Again, this is a verbal error, which is easy to correct, and one has the material to correct it, because you have what you see in 4.6, and again over the page in 5.3, which in relation to sales of Campo shares, or otherwise, the development, you have a similar provision as you find in 4.6. So I submit that it is plain that 3.7, the wording in 3.7 as is makes no sense, and it has to be and can be corrected so as to be in line with what the judge himself pointed out. I can take you to it if you like. It's at page 86 of the core bundle, paragraphs 204 to 207, where he explains what the error was and how the correction has to be made. Now, I submit this is quite important in relation to 3.7, because if you read the sentence, if you read the second sentence of 3.7 as saying, if, however, following any such reorganisation, any real estate asset is subsequently transferred to a third party, the provisions of this clause, i.e. clause 3, shall apply, and JOP shall be entitled to any amounts payable in accordance with this clause, i.e. 3. That's the reorganisation. Then for the purpose of this clause 3.7, transfers of any real estate assets and so forth. And that makes sense. So what that means is you cannot read the last sentence of 3.7 as creating a general rule that all share sales are caught, as opposed to share sales in the particular circumstances of a reorganisation under 3.7. My learned friend places great weight on that, and he says, aha, everything might be against me until you get to the last sentence of 3.7. But look at that last sentence of 3.7. It, so to speak, gives me the escape route. Or maybe he'd put it higher than that. He would say that gives me the lever to get into a construction which allows you to read Valsa real estate as including the a share sale. I say
he does make a further point, doesn't he? He says that even on the judge's construction, there's an anomaly here, because the overall result, reading 3.1, reading the whole clause together,
yes,
is that you don't get a profit share in the event of a straightforward sale of the shares, but you do if there's a bit of jiggling about with the companies first, and then there's a sale of the shares.
Well, my submission, there are two answers to that. The first is this. I submit what this, well, I may give three answers, one of which I hope is good. But,
which is your best one?
I find that difficult to tell, but they're short. The first point is this does appear to be, as the judge held, essentially an anti-avoidance provision. What this appears to be directed towards is MGI saying to itself, why don't we, instead of selling this property, Cali Codal number 2, directly, why don't we just transfer it to a company in our group, and then the company in our group can sell it, and we can avoid the liability. And that is how the judge interpreted 3.7, and I submit that's a perfectly sensible construction. In other words, you can't reorganise with a view to transferring a property, with a view to then selling the property, share sale.
Anti-avoidance, it's a sort of penalty provision, isn't it? I mean, it's punishing you for reorganising your company.
Well, it's intended, I submit, to keep you on. That's one answer. It's intended to keep you on the straight and narrow. You can't get out of these obligations by transferring properties to a particular entity with a view to that entity then being sold.
Not only you can't get out of it, but you get into a bigger obligation as a result of doing it.
No, not necessarily, because my second point is this, is that I respectfully submit, what it envisages is a sale of, let's say, a single-purpose vehicle, or rather a transfer to a single-purpose vehicle, and the single-purpose vehicle then being sold on, which would, one assumes, you could work out the profit formula as easily by reference to a single-purchase vehicle, or special-purpose vehicle, as by reference to the property. But there's a third point. and it comes back to the point I made before lunch, when it says, for the purpose of this clause, transfers of any real estate assets shall include any asset transfers, as well as any share transfers of the company owning any such real estate asset. I submit that if there were to be, let us say, a sale of the company to whom the property has been transferred, then without attempting a sale of the property itself when there's a market for it, that would be a breach. Because in my submission, the fundamental point which runs through this is that the MGI always has to look for a purchaser of the property. And if it doesn't, and if instead of looking for a purchaser of the property, what it does is it just sells the shares without looking for a purchaser of the property, then it's in breach.
I mean, 3.7 is an unusual clause. If you go back to...
Yes.
Well, sorry, it's not unusual necessarily, but it says on one view more than it needs to say. If you go back to 3.1 and 3.2,
Yes.
and particularly 3.2, it talks about a real estate asset, but the real estate asset as defined must be a real estate asset owned by Valsa or Vesa.
Yes.
That's the first condition. And then it's sold to a third party unconnected to the purchaser on an arm's length basis. So that's the trigger.
Yes.
So the first sentence of 3.7, to say no amount shall be payable in the event that the purchaser reorganises the group so that any real estate asset is transferred within the purchaser group. Well, that wouldn't be a trigger anyway, because it's not to a third party unconnected to the purchaser. So it's sort of just re-emphasising that. But they're then saying, following such reorganisation, any real estate asset is subsequently transferred to a third party buyer. Well, that's designed to trigger the clause, even though when it was sold, the real estate asset, it wouldn't fall within the definition of real estate asset because it wouldn't be owned by Valsa or Vesa. It would be owned by another company within the group. But it's saying, that would be. So that would be dealing with one anti-avoidance or one sort of scenario where there'd been an internal reorganisation of properties and that the sale to a third party was not of an asset which at the time it was sold was not owned by Vesa or Valsa, even though it had been when this agreement was entered into. So it's sort of follow the asset still. So that's, I think, understandable.
Yes.
And then it's the last sentence which is then the only thing that then drags in the possibility of share transfers. It's rather curiously worded because it said it shall include any asset transfers. Yes. Well, it only applied previously to it. It's the wrong way around.
Exactly.
But what I think it is clearly attempting to say is it includes share transfers of the company owning any such real estate asset as well as transfers of the asset itself. So it's trying to indicate that if there's a sale of Newco having been the company connected with the purchaser to which the asset was first transferred. So once you sort of disentangle the syntax, that it's certainly covered, and you say that's the full extent of it.
That's the full extent.
And you say that the fact that you could do all of those things with individual assets and have to pay a profit share on each of such sale as prescribed there. But you don't if you sell shares. You just say, well, that's not... It's not absurd because, and I think you're going to come on to the because.
Well, I submit there's no absurdity in that. This is dealing for a particular exception. It's as simple as that. It doesn't, in my to say that's absurd, it's not at the same level of absurdity as we have in Ireland and Britain. It's a result which one can understand the parties after negotiating might have wanted. My clients might well have said, one can imagine it, a notional negotiation where Mr. Ortiz-Patino says, I want to be I want the profit share to arise in the case of a sale of Soto. Right, I said, there's no way that's going to happen. And then he says, well, I'm a little bit concerned about you trying to get out of.
Putting aside the question about whether the golf course itself would ever be sold, just for a second, I know that's a different point. But on the face of it, if the technique had been used of selling either the assets themselves or the assets within an SPV, after first putting them into an SPV, every single time you sell every asset, you've got to pay a profit share.
Asset, property.
And indeed, if you had 50 separate, I don't know how many properties there are, but if you had 50 separate asset shares under which all the assets were sold, you'd have to pay effectively the profit share on the whole.
Yes. Assuming under the formula there was a profit in the first place.
Yes,
One has to bear in mind that this was a company which was very heavily indebted. This is why it matters.
But these would be undoubtedly these would be sales to which, assuming there's a profit, applying clause 3.3, you would have to pay the profit share. If for example, there were 550 company properties and you sold each of them individually or put them into little separate companies and then sold them on, you accept, profit share is payable on each of those occasions.
Well, I'm not quite so sure I'd go as far as that, but what I would accept is if what we did was sell the shares as opposed to selling the property, what the claimant could say, but you identified a buyer for the property, and what you went and did is sell the shares. And you're not allowed to do that. If you've got a buyer, let's say I've identified buyer X. I say to myself, for a particular property, plot R. Okay. I've got Mr. X, he wants to buy plot R. Yeah. And I then...
And Mr. R says, let's say, actually, I want to buy plot R, I'd pay you even more if you just stick it into an SPV and I'll buy the shares in the SPV, because that's actually the way it's normally done, tax efficient. Please do it. Better price.
But in those circumstances, what could be said is you could have sold, you had a buyer for the property itself.
No, the buyer's saying, I want to buy, put it into an SPV for me, please.
Well, my lord...
You've got to get the best saleable price.
I understand. My first answer is, this just isn't this case. But my second answer is, even if it were the case that you would, a profit share would arise on the individual, the obligation to pay a profit share would arise because of the sale of an individual company after a reorganisation. I say that does not give rise to any absurdity.
No, but so you haven't sort of heard my question in a sense. I know you're jumping ahead to give me your answer, but because the point is, if you had let's say 5 individual properties, and that was the totality of it. You would have to pay a profit share on the sale of either each of the properties separately as a property, or indeed if you shifted them each into an SPV just beforehand and sold the SPV, you would have to pay the profit share.
Yes.
Correct?
Yes, I can see that.
So you do them all, in fact, do them all at once, you'd have to pay the profit share on all the 5 separate transactions.
You mean after a reorganisation?
Yeah, well, if you shift them in either individually as assets or shift them each into a separate SPV and sell the SPVs as a job lot, you'd have to pay the profit share on that. But you say, oh no, if you sell the shares of the company above them that actually originally held those assets, no profit share.
I say certainly no profit share.
And that I think is the high watermark of the case on absurdity that's put against you, because it's a commercial absurdity that's put against you. It said that your clear words produce a result which is commercially absurd.
Well, I say it's not.
But you are going to come on to the reasons.
I'm going to come on to the bigger point in a moment. But just on this point here, what I would say, what would the proper construction would be, is that if I have identified a buyer for a property, and what then happens, and I have then, so to speak, avoided the profit share by, you might even say, by agreeing to put it into an SPV, because that's what the purchaser wants. But he undoubtedly wants the profit. He undoubtedly wants the property. It might well be the case in those circumstances that what could be said against me is, you had a buyer for the property itself. You did have that, and that was sufficient on a proper construction. That was sufficient to trigger my right to a profit share in relation to the sale of the underlying property. You could have got, let's say with the SPV, I get 1 million, but with the property alone, the sale of the property alone, I could have got 800,000. Let's say, for the sake of example. And what the claimant could say is, well, okay, I know I can't get a share sale, I can't get profits of a share sale, but what I am entitled to say is, you had the opportunity of selling that property itself on the proper view, and you didn't at the best saleable price, and you just didn't. So you have deprived me by your own actions of the profit share which I would have got had you sold the underlying property. And that, I submit, is how it works. And that way, my lord, if one of the questions is, how does one give sense to all this? And I submit that's a better way of giving sense to it than doing what I do say, the judge is right to say, violence to the wording of clause 3, which treats an asset sale as a share sale. Sorry, treats a share sale as an asset sale. And so I do urge upon you, my learned friend's way of trying to give sense to the agreement is, in my submission, not the right way. One focuses always on my obligation is to identify buyers of the underlying assets. And can I put it also this way? There can't be said that my obligation was to identify purchasers of shares in SOTA. That doesn't make any sense. It's impossible to read the 3.1 in that sense. And indeed, how can one read the obligation as an obligation to find buyers for the Valsa investor shares? So that, I submit, is what it all goes back to. I might well be in breach of an agreement if what I do is I effect a share sale rather than effect a property sale when that was open to me to do. But my lord, I do also submit this doesn't give rise to any ambiguity. You might say, well, for whatever reason, on the proper construction of the words, there was the ability, or rather there was a right in the appellant to share in a profit share of a share sale in this particular circumstance. It certainly doesn't, in my submission, follow that it is absurd that the rest of the agreement doesn't provide for that. Indeed, one might reasonably ask, well, why is the absurdity that way round? Why doesn't one start from the premise that actually it is clear what this agreement intends, namely the sale of properties and the right to participate in the sale of properties? There does appear to be an extra right at the end of 3.7 to share in the asset sale, a share sale after a reorganisation. That can't affect the rest of the agreement. And in my submission, that doesn't result in a commercial absurdity of the sort which is required, any more than there was commercial absurdity in Ireland and Britain. You might just say there is an anomaly here, at most, but not one that makes the whole agreement absurd. Can I also just refer you back to Arnold at paragraph 18, page 13 of the authorities. And if I can just ask you to read that yourselves.
So which paragraph?
18.
Paragraph 18.
Paragraph 18. And I submit the point is obvious. One might say there's an infelicity in the drafting here. It's not quite clear why the last sentence has been added. But it doesn't follow that what you might call tail end cannot affect the whole body of what has gone before.
Well, I think it's quite clear why the last sentence has been added in the context of 3.7.
In context of reorganisations, yes.
Well, in the context of, reorganisation is the shorthand for the transfer of a real estate asset within the purchaser group.
Yes.
It's to make good an anti-avoidance provision. The question is whether, as I keep coming back to, I think the question is whether, given the introduction of such an anti-avoidance provision, it is absurd that the parties wouldn't have intended the rather bigger one that was staring them in the face.
In my submission, no. And you cannot work backwards, if you like, from a small provision to a big, so say the rest of the contract must be read in line with that small provision. My submission is not. There's nothing absurd as such. I say, if you didn't have the tail end of 3.7, I say there's, for reasons I shall come on to later, there's nothing absurd in the agreement. There's a proper protection all the way through.
When you do have the tail end.
Sorry?
But when you do have the tail end of 3.7, there is something absurd.
No, I say there's absolutely nothing absurd then either.
Still nothing absurd.
I say there is nothing absurd in the sense one has to use the word. In the sense the word is used. It doesn't mean that you have to, that it makes no sense that the rest of the words, which are entirely clear and plainly proceed upon one premise, have in fact to be interpreted in accordance with a different premise, to which they just don't fit. And if I can put it this way, if you just looked at the rest of clause 3, you say this obviously doesn't apply and cannot apply to share sales. The language is entirely inappropriate all the way through. And in particular, share sales of SOTO, because there's absolutely no provision, as you'd expect, for the purchase price of SOTO to be taken into account. Investments, nothing. Very difficult to see how clause 3 as a whole could be said to apply to SOTO. And that, I submit, is the main, one has got to look at what you might call the big point first. The big point is this makes sense on its own, and it obviously doesn't apply to SOTO. Then the question is, well, what about the last sentence of clause 3.7? And you have my submission. I say it doesn't create an absurdity in what is said elsewhere. It creates a particular right in a particular circumstance. One might say, why was that right not extended to the rest of?
Well, you'd say, for example, you can relatively easily bend 3.3 to fit an SPV into
Yes.
which a real estate asset is transferred prior to sale to a third party.
Yes.
Because the SPV wouldn't be doing anything else. And in a sense, you could probably bend 3.3. But you say SOTO is a different kettle of fish altogether. It's not an SPV. It's a well, actually, we don't quite know what else it did, but it certainly has more operations than just a newly formed SPV, I think.
Well, absolutely. And of course, it will incur all sorts of debt, and my clients have spent a lot of money purchasing it. And this is, I would say that's 3.3. It simply cannot work at all. So, I suppose, in answer to the point, I say there's nothing absurd within the meaning, which we're caught within the meaning the authorities give that phrase. There has to be more than a drafting infelicity, it has to be more than a drafting anomaly, which gives a right in a certain circumstance which doesn't exist in the other. But the starting point, I suppose, is the big set of rights, rather than the little right at the end of the 3.7. Well, I submit that's the right way of looking at it, and that's the right way around. You can't start with the anomaly. What I say is the anomaly at 3.7, and so you've got to recast the rest of the whole of clause 3, especially in the light of the fact that draftsman is obviously well aware of the difference between share transfers and asset transfers.
And what do you say? I mean, some of your submissions have been on the basis that the last sentence, why did they include the last sentence of 3.7 at all? And that's what gives rise to the difficulty.
Yes.
But what do you say about a construction of 3.7, which is on the basis that the last sentence is perfectly natural to have when you're looking at a situation in the rest of 3.7, which is seeking to avoid the get out by making the asset not in the hands of the 2V companies.
Yes.
And that therefore it's natural that they're looking at an SPV situation,
Yeah.
which would mean also that it would be natural that they would want it to cover off all elements of get out by
Yeah.
putting in the last sentence.
Yeah. Well, I do say that. I say exactly that. That is indeed. That was the point I briefly made. I think.
Yes, but I think
wasn't
you
too well,
slightly.
But I went off it. Yeah. But that I do. I'd say that is right. It does make sense that way. In other words, I suppose one can give final clause, final sentence of 3.7 cents by interpreting it as intended to cover the situation where a property has been transferred to an SPV, and then you can apply the rest of clause 3.3 to that particular transfer of the SPV. Just one other point.
And why do you say Valsa and Visa are not the same as an SPV?
Well,
They obviously they own the trademarks as well, which
Yes.
means that they're not that special.
Valsa will be earning income from the rent. The golf
I
course.
did recollect, I put to Mr. Blake that I recollected that the judge made a finding about that.
Well,
Can you
only
maybe I can-
because, yes, but that was not envisaged at the time. The purchase agreement was entered into it. When the PSA is entered into it, none of that's the case. It's only later that the rent goes into the escrow account, but it certainly wasn't part of the arrangement my clients intended to buy into, but there's no rent coming into Valsa.
But so at the date there was rent coming into Valsa, and that was known to the parties to the SBA.
I can't say exactly what they knew, but it was known that there was rent that was payable. And the only reason it was
I
being put
recall
in-
seeing a finding of the judge. I just wonder if anyone of your juniors can identify where that was. That the judge said there's more to Valsa and Visa than just the properties and the trademark.
well, there certainly would have been the rent, the right to the rent anyway.
Well, I know you say that, but I'd like to see it in black and white in the judge's judgment.
But perhaps my lord, we can
Yeah.
chase that down. But in any event, I say that cannot affect the main point. You have my point about how does one construe 3.7? And I submit it's the way which was put to me by Lady Justice Asplin is the most natural way. But that you can't move from that to a giant, essentially a rewriting of all of clause 3.
So let's just pick that point up for a second with Vesser, which makes it
Yes.
slightly easier, because
Yes.
Vesser has, I think my understanding is correct, Vesser has 11 separate saleable plots of land.
Yes.
Plot 1, which is subdivided into 5 plots, 2 plots of land at Soto Alte, 3 plots of land at Calais Ebro, and a villa at Calais Fonda 28.
Yes.
Then it's got some related trademarks related to the golf course by the look of it.
Yes, it does have some. Not all.
Some, no. So we got Vesser. Let's just take Vesser as the easy thing. So you've got an obligation to look for a buyer for the real estate assets owned by Vesser.
Yes.
Sell them at the best possible price. Correct.
Well, identify buyers.
Yeah.
At the best
Okay.
possible price.
And if you sold them either raw, in their property state,
Yeah.
you'd pay a profit share.
Very unlikely. But in the sense that was no, the evidence I think was broadly that
Development and sold.
a lot of these properties have been foreclosed on, mortgaged up.
Okay,
to
but
yes, in principle, yes.
You sold them as real estate properties.
Yeah.
You pay. If you put any of them, if you put any of them into an SPV for the purposes of sale, you would pay because of 3.7. Yep.
Yes.
You say if you sold the shares in Vesser, there would be circumstances in which you'd also pay a profit share, which you addressed before lunch.
Yes. Well, what would be said against me is you went and sold Vesser when you could have sold the underlying
Well,
properties.
yeah.
And you made no reasonable endeavours to sell the underlying properties.
Right, but you accepted, I think, that it would be implicit, or for some to give efficacy to this agreement, you'd have to pay a profit share if you sold the shares in Vesser.
Oh, I don't know. No, I wouldn't accept that. No,
In certain circumstances.
in certain circumstances. but certainly not if I'm acting in good faith and it's a genuine share sale for good and proper reasons. But I certainly wouldn't accept that in the generality of things.
Where do we get that in this agreement?
Well, I submit what you do get out of it is I couldn't sell the shares in Besser without first having attempted to find buyers for the underlying properties. And if I did that, and there was a market for the underlying buyers, for buyers in the underlying properties, then I'd be in breach of the agreement. Because what would be said is you broke your agreement to identify individual buyers for the individual Besser properties. You could and should have done that, and had you done that, it would have been a nice profit. That's the right they've got. And so it's not the case that by virtue of the sale of the shares in Besser, the claimant is entitled to a profit share assessed by reference to the shares or the share price.
You say it's damages.
It's damages for breaking the agreement to look for a buyer of the underlying property.
But suppose you did look for buyers of the underlying properties,
Yes.
compliant with 3.1,
Yes.
and then somebody said before consummation, so there's no breach of the agreement, there's no breach of 3.1, you looked for buyers, you found a buyer who said, I'll buy all 5 properties, and then he said just before the sale, actually, I'd be perfectly happy to take sale of the shares of Besser in its entirety, and you thought, oh, that's quite handy. We won't have to pay the profit share. Is that and you consummate that transaction? Makes perfectly good commercial sense from his point of view. Makes good commercial sense from your point of view, because you don't have to pay a profit share. What's the answer there?
Well, my lord, you'll forgive me if I give alternative answers. My first answer is bad luck under the profit share arrangement. In other words, no liability at all, because no liability even for breaching the term that I would look for buyers.
Yes.
The alternative construction would be that in a circumstance where I have found and demonstrably have found a buyer for 4 properties, but then the transaction has been structured as a share sale, then in those circumstances, the claimant might be able to say, to give effect to the commercial sense of the agreement, you must give me the profit share that I would have earned had you gone ahead and sold those properties, quay properties.
Why?
Because, one has to, in order to give sense to the agreement, that would be, my argument would be, you don't have to go that far, but if you wanted, so to speak, to make sure that the claimant had a right to a profit share in those circumstances, you would say the right applies only where you've been deprived of, I haven't even looked for, or I have looked for and found, but then not gone ahead with a sale of the property itself.
But are you saying that that's necessary? You're saying if we wanted to, I don't think we. What we want is a relevant yardstick. But are you saying that in order to provide a commercial sense, that is necessary?
Well, I would say no. But if the court were to find, as it were, that it make my primary construction makes no sense. Supposing one says your first construction makes no sense because you can just get out of the obligation to pay on the sale of the 4 Besser properties by a sale of the shares instead. That can't be right. But I submit the way if it is wrong, if I'm wrong on that point, then the answer to it is simply that there would be a right in damages. Because I've gone ahead and sold shares when I could have sold the properties, or at least I had identified buyers for the properties. And then...
So it's either damages or, I think you were saying, it's some implied term which enables you to do so where there's been bad faith.
Yes.
And you would say switching, and that's a big question, whether that's bad faith or not, but switching from selling the properties to selling the shares is bad faith.
Well, it might be, but
It might be not.
Yeah, might be, but that's an argument that would be available on a proper construction of this agreement, or indeed maybe by an implied term. But I'm meeting what you might call the commercial absurdity point. It's being put to me my construction results in commercial absurdity. My first answer is it doesn't, and certainly not for the purpose. It doesn't get to the high bar. But secondly, even if you thought this was pretty anomalous, it can't be right type of thing, then in my submission the answer is, because of the structure of the agreement, I would be in breach of my duty to identify.
But it's the last bit I don't get, because we just very easily postulate an example where you completely comply with your obligations in 3.1. You advertise, you go out and say, we've got this, Vesa has got these 5 properties, buyers come forward.
Yeah.
And somebody comes forward and says, I will buy all of the 5 properties, or I will buy the shares in Vesa.
Yeah.
And you say, okay, I'll sell you the shares in Vesa. And you seem to, now, and I'm struggling with this, because you seem to say that in certain circumstances that might give rise to an obligation to pay. And I think you a moment ago accepted, I thought, that if you could have sold separately but chose the properties separately, but in fact chose to sell the shares, you might, in order to give business efficacy to this agreement, be subject to an implied term that you would pay the profit share. Now, have I got that wrong?
Yes. No, that would be right. If I could have, I would be liable to pay damages by reference
It's not
to
why is it damages?
But because I've broken the agreement.
Well, you haven't. On my hypothesis to you did nothing to breach 3.1. Which other term of the agreement would I have breached?
No. But my primary position is none.
So I put together. So I'm trying to tease out from you why you are conceding that in those circumstances you would end up playing a profit share, because once you allow that nibble in your shield of armour, if I can mix my metaphors, you are, as I see it, opening the door to a thin end of a wedge or whatever other sort of sequences.
No, my primary argument would simply be there is no obligation upon me whatsoever to pay a profit share if I, in good faith and so forth, sell the shares in Vesa, even if I've had a previous offer for the individual properties.
Right. So
that's my primary position.
Right.
An alternative position, and I say this would not, however, open the door to everything, is if in fact it could be demonstrated that what had actually happened is I had received an offer, or effectively you could say what I'd done is I'd received an offer for the 4 properties, and then we've decided to put the thing together as a sale of the shares, then in that circumstance, where one might say I could have sold the individual properties but I didn't, there would be a right to damages for not selling the properties when I could and should have done. But
what's the clause that's breached that gives rise to that? Well, hang on.
An implied term. An implied term is the answer.
Well, what's the implied term then?
The implied term is I will not do anything. I will not take steps which are designed to defeat the rights of the claimant. When I have found a purchaser, I will. If I've got a purchaser ready, willing, and able to buy, I will not take steps. A particular property. I will not take steps to deprive, as it were, to avoid that transaction, and enter instead into a share sale. And if I do that, then I'm in breach of the agreement. I might do it for good commercial reasons, but if I do that, then I might well be in breach of the implied term. That I will, if I've got a buyer, I will go ahead and sell to that buyer of the property. That would be the implied term. And then, however, this is important, the profit share would be assessed by reference to the factors, and naturally by reference to the factors in clause 3.3, 3.2 and 3.3. And that the damages would then be assessed. But you would never be looking at the price of the share sale. That would be an irrelevance. But what you would be looking at is how much could you have got if you'd sold that property on its own. And that, in my submission, if it was felt that there's a commercial absurdity in the agreement, that is the way to solve it, because it does no violence to the language of clauses 3.1 to 3.6 and 3.8. There's no violence at all. I'm conscious of the time, and I've spent most time on what you might call the big points. You would have read my skeleton. I don't. That I think deals with what you might call the absurdity point. But the other point I particularly want to make is on the facts of this case, whatever one might posit in other circumstances, on the facts of this case, I submit it is impossible to say that a sale of the shares of Soto come within these provisions. And I do submit this. On my learned friends construction, you get what you might call reverse absurdity. Supposing the position, and perfectly recently, the position was, can't actually find any purchasers of these properties on their own because I haven't been able to develop them and they're all loaded up with debt. And frankly, I haven't been able to find any purchasers of Valser and Vesser. Difficult to find anyone there. Does it mean, my learned friends construction, I would have thought it does it mean I've then got to say, oh dear, I suppose I've got to sell Soto now? If Soto's a real estate asset, have I got to look for buyers of Soto? Why can't I hold on to Soto? And I submit it cannot be the case that I'm obliged to look for buyers of Soto. That would make no sense at all. And that would be a reverse absurdity.
Well, aren't you tilting at a windmill there? I mean, where could it be suggested in this agreement that you were under an obligation to look for buyers of Soto?
Well,
as a company.
Well, because it is because I'm being asked to pay a profit share by reference to the money, the such profits as it is said I made on the sale of the shares in Soto.
Right, but I didn't understand it. It's necessarily suggested that we should interpret 3.1 to apply to as an obligation to look for buyers.
Yes.
I think what's suggested is when you interpret 3.2, which is sale as
yes.
a transfer, you include the shares of Soto to apply the read across. But I don't think anybody suggested, or maybe I've misunderstood, but I didn't think anybody suggested that you read across from the last sentence of 3.7 to the obligation of 3.1.
Well, if that's right, then that point goes. I can see that.
I mean, I'll be corrected by somebody if I'm wrong.
But
no, your interpretation is correct, man. That is how I put it. And the ambiguity is particularly focused on this ambiguity between sold or sale and transfer.
But anyway, my lord, just going back to 3.1, 3.2, I respectfully submit it is impossible to see how the sale of Soto can amount to a sale of a real estate asset. And so forth. But you have it. And especially, my lady and my lords, I say this, just on the bigger absurdity point. I did make the point earlier, but I can, if I just may, just repeat it. If we had made no attempt, or if we had not used reasonable endeavours to find buyers of the individual properties, if that had been the position, and we then went and sold the shares of Soto to Zagaleta, then I can see there would be a clear case of saying you acted in breach of the agreement, because you didn't look for buyers of the underlying properties. And had you done so, you'd have got plenty of money. That I can see. But if, as you have in this case, a position where it is not suggested that there were buyers of the underlying properties to whom we could have sold at a profit, I submit that we have done, there's no basis for saying we've done anything wrong, and no basis for saying there should be a profit share, however one cuts it. And all the problems that have been put to me essentially arise on the premise that there are actually buyers of the underlying properties. But what if the position is there are no buyers of the underlying properties? And I think, my lord, my lady, if I can just ask you to please to look at paragraph 54 of the judgment at page 132. The core bundle. I think it's paragraph, sorry, I picked up the wrong bundle. Paragraph 54, page 132.
Of the judgment.
Of the judgment.
Hang on. Page 50, paragraph 54 at page 132 is a paragraph in the pleading.
54 of the judgment is at 35.
Oh, sorry, forgive me, it's the wrong. Sorry, page 90 of the core bundle, paragraph 223. Many apologies. Now, this is where the judge is talking about one of the claims which is dismissed and is not the subject of an appeal, which was that my clients could have sold Soto for more. But you'll see what is said in paragraph 223. These claims did not involve an assertion that MGI would or could have obtained a better price by selling individual properties or trademarks, or that by selling the shares in Soto and Campo, MGI was acting in breach. Now that I submit is fundamental. This is not a case where that was the claim against me.
Sorry. 222 says that the claim for net profit is on the basis that you were in breach of its obligation under 3.1 to identify buyers for the real estate assets at the best saleable price.
Yes, but that meaning of not the underlying properties.
Oh,
the claim against us was not put on the basis. You could have got a lot of money for these underlying properties. More, the claim was simply put, you should be giving us an even bigger profit share of a sale you could have made of Soto than you did. It was not put on the basis that there were sales of individual properties which, qua individual properties, would have yielded more on a net profit basis, or would have yielded anything. In other words, the focus was not on you could have sold 5 properties at this price. You failed to sell the 5 properties at this price, therefore you should pay me by reference to the sale price you could have got on those individual properties, less the mortgages on them. The way it was put was, and this is why the judge says what he says in 223, the way it was put was, if you'd made better efforts at selling Soto, you'd got a better price for Soto. And this all goes back to the same point. The claimants were always looking for profit share by reference to the sale of the shares, not a profit share by reference to the sale that could have been made of the underlying properties. And you see that in particular, I think, from 224, my lord.
How does that help with interpretation?
It doesn't. Well, my lord, forgive me, it does in this respect, because my point is if the claim had been put on a different basis, namely, you went ahead and sold the shares when in breach of the agreement, because there were plenty of buyers out there who would have bought the individual properties, then there would have been a claim. I mean, we say there wouldn't because there was no profit to be made, but that's a different point. But what you can't do is say that these provisions also entitle the claimant to a share of any profits that might have been made on a share sale.
That's exactly what is being said on the basis of the last sentence of 3.7 having a life of its own, if I put it that way, and translating that back into 3.1 and any and all.
Yes.
And that is what is being said.
Sorry, my lady, that is indeed the claimant's case. But what they're saying is the profit share formula works on the sale of shares, which we say that is indeed their case. Yeah. They have never been alleging, on the other hand, or they certainly didn't allege at trial, that you could have if you tried to sell the individual properties, you could have got more. That's the point.
Yeah.
And that's what I say in answer to the absurdity point. There was protection for the claimant here if we had simply not, if we'd made no effort to sell or find buyers for the underlying properties. And that's the protection they had. And just if I may briefly, you have my points from the skeleton, so I'm conscious of the time. Can I just move off the absurdity point for the moment? Just onto the point that the limitation to of the profit share to sales of properties was explained by the context. And there's no mistake.
This is point 2. Your
Point two.
Yeah.
Yeah. The first point, this is a professionally drawn contract. That's obvious. The judge finds that. And the draftsman obviously knew what the words meant in clause 3. The second point is there are much wider rights for Job, or Mr. Ortiz-Patino, in relation to sales of Campo. And I'm conscious of the time, but in particular, he has the right, if you look at clause 5.8, he has the right to make matching offers and indeed to bid for Campo. So the position for Campo is in contradistinction to the position on the Valsa and Vessa real estates assets. And in particular, I think you find that clauses 5.8 and 5.9 I'll just give this by way of example, but you can see 5.8 there's a provision that if Campo or Valderrama 7 or the development aren't sold by a particular date, we are going to have to increase the amount of the facility of the Putter loan. And then 5.9, Mr. Ortiz-Patino shall be entitled to identify third-party buyers, the Campo Alto shares, the VO7 shares, or the Castel, as well as take any measures and steps in order to obtain the best saleable price. Now, he's got nothing of the sort in relation to Valsa and Vessa, or the real estate assets. And in 5.6, he's got the right to make a matching offer. I don't suppose to take too much time on that. But he's obviously got far more rights in relation to Campo. Again, all this is quite deliberate. It's true, my lord, that I say the context is important, namely the flotation of MGI. Can I just ask you first to go to page 35 of the judgment, or the scorecard? And this was the original investment memorandum by the Strike Group back in 2010. You can see this was always going to be the idea, and everyone knew this.
So which paragraph?
Paragraph 55, page 35.
Is this point 3?
This is back in 2010. This was the idea. This is just really, I just want to show you what the point always was. And then page 59, proposed listing of MGI shares, paragraph 119. In particular, subparagraph 4, this is what was always envisaged.
Sorry. Paragraph, sorry. Which
Paragraph 119 on page 59.
So,
And then the judge, just for your notes, my lady, my lord, there's judge explains in paragraph 122 to 126 why, in fact, the listing didn't go ahead. Essentially, there were a number of problems, and the books and records weren't handed over to my client.
so what I'm not quite following, and what I was going to ask you, I was reading it twice, is that in 55, TSG had a slightly different idea, which was started out the same with the development of land, not including the golf course, exploitation of trademarks.
Yes.
And at the end of the term of the fund, 5 years, by the sale of Soto. So TSG was certainly envisaging the sale of Soto.
Yes.
And you say, well, you then compare it with what MGI was planning to do, which is in little Roman 4, everything else was similar to what TSG was doing. But then in 120, saying that they probably would exit by selling shares. Okay, so that is consistent, but only at the end of the life of the fund. Okay, so it is the same. The judge says.
And the judge goes on to say that.
So is this right? Do we take from this that at the time that the profit share agreement was entered into in 2012, that part of the matrix was that there would ultimately be a sale of the shares of Soto, including the golf course, which would carry with it the golf course, which wouldn't have been sold during the life of the fund?
Well, and that the judge, I think, more or less finds as much, that was part of what was understood. But the more important point, of course, is that there was going to be development of the individual properties.
If I'm looking at what the matrix of fact known to both parties at the time of the 2012 agreement was, let's assume that the parties knew of the publicly stated positions of TSG and MGI. TSG would have intended a sale of the shares in Soto because that's the only way that they would sell the golf course at the end of the fund. MGI had a prospectus which didn't refer to that.
Yes.
Referred to everything other than that.
Yes.
But the judge finds from Mr. Monkson's evidence that at least MGI had that intention that at the end of the life of the fund, the shares in Soto would be sold. But is that latter point, which is not explicit in the prospectus, is that part of the matrix of facts surrounding the agreement or not?
Well, yes, but only as a rather distant one. I accept all these are parts of the matrix of fact, but the more important matrix of fact is that there's going to be development of the individual properties.
Yeah, I understand that, but I'm just trying to... Do you accept that it was part of the matrix of fact known to both sides at the time they entered into the 2012 agreement that there would not be a sale of the golf course as a real estate asset, even though it was owned by Valsa, but that it would ultimately be disposed of through the mechanism of a sale of the shares in Soto?
Well, that was certainly MGI's understanding. The judge does deal with what both parties knew, which of course
in that specific regret.
In that specific last respect, because the judge does make findings. I think the next is at page 62, paragraph 120.
That is 120.
Sorry, 62, 129. Forgive me. Paragraph 129. Strategy changes late 2013, early 2014. And 130, it wasn't able to pursue its initial strategy. And then page 84, paragraph 199. I submit this is an important paragraph.
I'm not sure it really helped. I'm not sure this really helps on the question that I asked arising out of paragraph 120. Because the judge seems to accept that both TSG and MGI, at least initially, had the same basic idea, which was during the life of the fund, generate income by developing and selling land not including the golf course and exploiting the trademarks. But at the end of the term of the fund, which for TSG was 5 years, and I'm not clear what it was for MGI, but maybe it's the same, you sell the shares in Soto. Now,
Well, that was certainly MGI's intention.
yes, and so my question was there any finding or is it any suggestion that that was known to and envisaged by both parties, that there would, at the end of the term of whatever fund it was, be a sale of shares of Soto, which would be the vehicle holding the golf course?
Paragraph 210, my lord, page 87. This, I think, is a fundamental point on the factual matrix at the time the agreement was made. Can I just ask you to read 210 and 211?
I mean, there's maybe a point in your favour in the sense there is no factual finding that both sides understood that there was going to be, or that it was at the time of the 2012 agreement, that it was the plan of MGI to sell the shares in Soto.
There's no finding to that effect.
And include, which would have given control of the golf course, because it was not anticipated that the golf course would in fact be sold at any time during the life of the fund.
Yes.
So
I mean,
if you go back to your obligation under 3.1,
yes.
your obligation under 3.1 can't mean what it says. Or does it mean what it says?
In relation to the golf course.
Correct.
It can certainly mean what it says. My obligation is to identify buyers. The fact that it may be reasonable endeavours, the fact that I might not be able to do anything with it, is neither here nor there.
But if the parties both knew that the whole ethos of the fund, whether it's TSG or MGI, was to retain the golf course during the life of the fund, and only at the end of the life of the fund to sell the shares in Soto, then how do we read 3.1?
Well, in my submission, you read it in accordance with its natural construction. It may be, the first point is what does it mean? And it says all real estate assets.
Well, you told us that it clearly and unambiguously means everything, sell everything as a real estate asset, not the shares in Soto.
Well,
if you'd have stopped the parties at the time of the agreement and said, excuse me, does that mean for the life of the fund we've got to try and find a buyer for the golf course as a real estate asset? The answer from both of them would have been what?
Well, it may be that both of them would have said, no, you don't. But that, in my submission, gives rise only to a limited exception. It certainly doesn't justify my learned friend's construction. One might say, well, it was a common understanding, and indeed, there might have been. For instance, supposing the case had been this, we had been criticised for not finding a buyer of the golf course. Let's say that had been the case, and the claim was brought against us on that footing. No doubt there might well have been room for a common estoppel. Let's say both parties knew and operated upon the assumption that actually there was no obligation immediately to find a purchaser for the golf course itself. But that is as far as it would go, if both parties understood that that was the proper way of looking at it. It doesn't help my learned friend on his wider construction at all. It would simply give rise to a defence on my part if we had been sued on the basis we failed to identify buyers for the golf course. But that wasn't the case against us.
But if that's right, your submission as to what the parties actually intended here is this. You would have to say that what they meant was, over the life of the fund, you should try and find buyers for all the real estate assets, namely everything else except for the golf course.
Well, the agreement itself wouldn't mean that, but there'd be a conventional stop which would prevent either party, if I put it that way, from taking a point to the contrary.
And therefore, you'll get a profit share on all the sales of all the other ancillary properties that you can find buyers for the life of the fund. But the one thing you won't get is a profit share on the sale of the shares in Soto, which we all understand is the only way that the golf course itself is going to be sold at the end of the life of the fund. So that's what, on your interpretation...
Well, that's what it would be. But it wouldn't prevent us from selling Soto. Yes, I mean, that's exactly what I say.
Yeah.
And I say, why not? I mean, this is, I keep coming back to the obvious one, the professionally drawn contract, and one just starts with the words themselves. It may be that conventional estoppels would have arisen in certain circumstances, other than in this case, which didn't arise in this case. And I do keep coming back to this point. You've got to deal with the particular facts of this case and the particular words, rather than hypothesise on different scenarios which might have given rise to difficulty.
Is there any other extraneous factor which supports the proposition that the JOP was prepared to accept a profit share over everything other than sale of the golf course, but didn't negotiate, agree, or expect a profit share on the sale of the golf course itself?
Well, we don't know, because that wasn't an issue in the case, and all we know is that these were the terms agreed.
It is. I mean, it sort of is an issue in the case, because actually everybody's gone uphill and down over every conceivable inch of this turf. I find it difficult to believe that nobody actually addressed their minds to that rather obvious question.
Well, for what it's worth, my client's evidence was that he believed there was a schedule attached which excluded the golf course. But anyway, that was Mr. Moxon's understanding. But I can't take it any further than that. The judge didn't make any finding on that.
Okay, well, the judge didn't. There's no finding that helps us address that particular question.
But I submit, whatever the answer to that question is, it doesn't affect the underlying, the underlying construction that you have to place on the rest of the words. They're entirely clear. The fact that there may be a question mark over the golf course itself, I submit, doesn't take one very far. Because if, let us say, what had happened, the reality is this. If let's say, we were supposed to find a purchaser, and you might say you should have made reasonable efforts, there was no obligation upon us necessarily to sell. We have to make reasonable endeavours to find a purchaser. It doesn't go on to say, and by the way, if you do find a purchaser, no matter what the difficulties are, or no matter what the low price was, you've got to sell to that purchaser. That's not what the agreement says. If I can go back to clause 3.1, it is a very limited right that is granted. We must identify buyers. And it doesn't go on to say, and if you do find a buyer, you've got to sell no matter what. It doesn't say that at all. And so this is essentially, it's in our gift as to whether we go ahead or not. But if we do go ahead, then he is entitled to a profit share with the sale of the property. But if we don't, then he's not. And you say, the point is put to us, well, surely that's entirely uncommercial. Which we say, well, no, when you look at the judge's findings, they're replete, but you'll have seen, he constantly says that Mr. Ortiz-Patino was in a perilous financial position. And I think we collect them together.
In relation to that, Mr. Blaker says that's an impermissible use of subjective or something which is outside the matrix.
No, I say that's not right. Because if you're talking about does this agreement make commercial sense, I submit one is perfectly entitled to take into account, as the judge did, that the seller was a distressed seller. That is a perfectly proper consideration. If what is being said is, this agreement makes no sense from my point of view, which the answer is, you bet it doesn't. That's because, on the one hand, you were in a perilous financial position, and on the other, we were taking on an enormous amount of debt. This was, if I can, I don't seem to be able to find the references for the time being, but there is no doubt whatsoever that the judge repeatedly says that Mr. Ortiz-Patino was in a perilous financial position. Can I just take you, for instance, to page 36 of the core bundle, paragraphs 59 to 60, and then page 57 at page 107. And I submit the court must take that into account. One of the difficulties, well, understandably, my learned friend says, just look at the profit share agreement. I say, no, you've got to look at the profit share agreement together with everything else that's going on. And we are taking on, essentially, a very large amount of liabilities. I mean, a very substantial amount of liabilities. And that's essentially what we're paying for. And Mr. Ortiz-Patino himself is on the brink of insolvency. He's unable to pay his bank debts, and very substantial bank debts. I submit that is manifestly a relevant consideration in deciding whether this is such an absurd agreement that you have to give the words a different meaning from the ones which they naturally have. If I can just deal with very briefly one or two other points. My learned friend says that the judge failed to give weight to certain points, for instance, admissions by Mr. Moxon, or the further information which I settled, and so on and so forth. We deal with that. I don't propose to go through it unless you wish. Otherwise, at page 298, paragraph 27 of our skeleton, we say there's nothing in that. The short point is you don't construe an agreement by reference to what took place subsequently in the absence of a conventional estoppel or claim for rectification. It's totally irrelevant. I might add, Mr. Moxon himself, the judge himself, finds, as I think I set out in that part of the skeleton, judge finds that Mr. Moxon himself was not the one who was primarily involved in the negotiation for the agreement. And he really only came into the picture, I think, in 2014. He was there before, but he was not the person who negotiated. I can wind up, I think, pretty quickly, just on the absurdity point. Just on the implied term and what I call the dirty tricks point, can I ask you please to go to page 89 of the authorities, paragraphs 29 to 31.
You're looking at Barton and Morris.
Barton and Morris. This is the majority speech of Lady Rose. And you'll be familiar, my lady, my lords, with this case. Essentially, the problem was the age, or a person had been told, get me a buy at 6.5 million. And he lands up getting a buy at 6.3 million. He lands up getting a buy at 6 million. And the deal was, get me a buy at 6.3 million, I'll give you whatever it is, £1 million. But nothing was said about what happened if the price was less than 6.3 million. Anyway, by 3-2, the Supreme Court said, he said nothing, bad luck, overturning the decision of the Court of Appeal, and it was a 3-2 decision. But anyway, the point I'm on here is about what is to be implied into a contract where this was an oral contract, but nonetheless, the question is this. Paragraph 29, the hearing before us, counsel of both parties accepted the concern expressed by a judge shared by the Court of Appeal was not a proper basis on which to imply a term, and so they go on. However, there is, in the quote halfway down, there is an implied term. You can imply limited implied terms of the sort, and I say that this is what one might imply here. what you might call an implied term to prevent my client playing dirty tricks. And that's it, what you see in the quote. It's the quote in 29 and then paragraph 31. I submit that, of course, the question might always be what is the scope of the implied term, but I would accept, that's what I said before, that we wouldn't be allowed, having got a buyer, let's say, of the underlying property, to try to get out of it. Now, there may be questions as to how far one takes this, but the basic implied term would be, I submit, along these lines. If we couldn't play dirty tricks and deliberately avoid our obligations by entering into sham transactions or the like, or entering into transactions which were deliberately structured, and we did so with a view specifically to avoiding what we could otherwise easily have done for no good reason, for no good commercial reason. Now that I do accept. But, my lord, even if one took that further to say, well, I think there should be a wider implied term to give sense to this agreement, it still doesn't lead to the conclusion for which my learned friend argues, namely that he's entitled to a profit share on the sales share as opposed to on a property share. And that would be the answer. If we had a different case before us, that in my submission would be the answer to the absurdity point that's put to me. But on this case, I say there is nothing absurd in the proposition that where there were no, and the judge has found, there were no buyers of the underlying properties, there's nothing absurd in the notion that we do not have to provide a profit share in relation to the share sale. And that is ultimately what this case is about. So that's why I say there is no commercial absurdity at all. 2 points. First, there's no commercial absurdity in our construction. And secondly, there's no basis for saying our construction results in there's no real basis for saying that on the facts of this case there are two alternative constructions. And I accept this much. Supposing you've got two alternative constructions of the words, which are both perfectly possible, and let's say one of them makes more commercial sense than the other, then I accept on the authority of rainy sky, you say, well, if I just looked at the words, you might be right, but I've taken into account everything else, and I think, I'm afraid you're wrong, Mr. Knox. Mr. Blake is right. I accept the court can do that. But my first point is, for the reasons I've given, there is no ambiguity in this document as to what the position should be on this transaction. Second, and that I say is an end of it, because there's no great absurdity. There's nothing terribly unusual. There might be odd points here and there. That's as high as it gets, but you don't get to that very high bar of absurdity. The second point, I say, in any event, there is no commercial absurdity. There is protection for the claimant. If he has the right to a profit share in the event that we sell, and what we cannot do, I would accept this, we cannot just somehow duck and dive to get out of that, when otherwise we'd be obliged to pay. We can't play dirty tricks. And given the difficult position Mr. Ortiz-Patino is in, there's nothing commercially absurd in that agreement. I don't think, really, you've got all my points, I'm afraid, repeating myself, but there are a lot of other points we've made in our skeleton in answer to various sub-points made by Mr. Blake. But I submit those are the really important points. In particular, there's a point about commerciality, absurdity and clarity. And those are the sort of big points we have to grapple with. But we say it would be very odd to say an agreement which talks only about real estate assets actually be construed as talking about share sales. But that's the simple one. Those are my submissions.
Thank you very much indeed. Mr. Blako?
Thank you, my lady. My lady, I note it's 6 minutes to 4. What time does this court propose?
4:15.
Yes, that's what I thought. My lady, I propose to deal with just a few key issues. Firstly, I wish to deal with the question of Soto and also the knowledge of that Lord Justice Snowden was dealing with about the knowledge in terms of both parties about a sale of Soto. And then secondly, I'm going to deal with this question of absurdity and in particular some of the authorities and the learning, in particular in Lewison, on that. Whether I'm going to be able to get through all of that now, I don't know, but there is...
I really think that it would be most convenient, put it that way, if you were able to finish your submissions today.
Right, thank you, my lady. Right, well then dealing really with Soto, if you can turn to 103 of the supplemental bundle firstly. And what we see there is the due diligence documentation. This is the KPMG document. And what I want to draw the court's attention to, I drew your attention to the 4th bullet this morning, but I now wish to draw your attention to the 5th, where it says that the holding tax status required that the following conditions are met, and it sets out 3 particular conditions. The 3rd one, halfway through that paragraph, is that a holding company may not be actively engaged in a commercial activity there in Switzerland. Now, and it says that according to the information we received, Soto met in 2009 and 2008 and 9 all the above conditions. And what I say is that all that Soto actually did was hold the shares of Valsa and Vessa, which in turn held the trademarks and the land. So that I just make that brief point. Now, in terms of piecing together various parts of the learned judge's judgment, if one can turn to paragraph 55, and it is, in my submission, necessary to piece various parts of information together. So paragraph 55, the judge refers there to what, at the time of the 2010 SPA, the aim was for TSG to raise funds for the acquisition from investors, that there was a memorandum, they were going to develop land, not including the golf course, and then at the end of the term of the fund, which was expected to be 5 years, by the sale, the returns would also be by the sale of Soto, holding an indirect interest in the golf course. That's paragraph 55. We then go on to paragraph 120, where it is said that there is no explicit statement of the exit strategy in relation to the golf course. However, Mr. Moxon explained his evidence. The aim was to sell the golf course subject to the lease at the end of the term of the fund, probably through a sale of shares in Soto, and he said he'd accepted this evidence as it's consistent with the prospectus and the earlier proposals. And what I say there is that JOP would have been well aware back in 2010 with the strike group's proposals and that this was merely a continuation of that. And then my final sort of piece of the jigsaw is at 211, page 88. JOP and his advisors would have been well aware of these proposals as the financing of the transaction with JOP was dependent upon it. Mr. Calantis, who's one of Mr. Ortiz-Patino's advisors.
I've missed the reference to the paragraph.
211, my lord.
Yeah. Thank you.
And this actually, sorry, it's also about, one has to probably read 210 because there it talks about the draft prospectus, the listing of the shares, it being 5 years, retained by MGI, and then it said, it doesn't actually expressly say about the actual sale of Soto, but in my submission that's implicit in terms of what would have happened there, and it says that Mr. Calantis acknowledged that he and JOP were aware of those proposals.
Well, the best that it gets is at 210 when it says it was known basically that the intention was that the fund would last for 5 years.
Yes, exactly. Thank you very much. Now, if I can now just turn to this question of, as I said, of the commerciality and absurdity. The first, if I can draw your attention to Rainy Sky, firstly, and it's Lord Clark's judgment at paragraphs 29 and 30. Now, what I say here is that we are dealing with a situation where there are distinct ambiguities in the agreement. Lord Justice Snowden has indicated and highlighted a number of those inconsistencies, and I have highlighted certainly in clause 3 a couple of them that I don't with the time intend to repeat, but particularly this idea of transfer and the sale of real estate assets, and the fact that those two are being used interchangeably. And what we see here in 29 and 30, page 445, Lord Clark sets out two extracts from the judgment of Lord Justice Longmore in Barclays Bank and HHY Luxembourg. In particular, there at subparagraph 25, the matter does not, of course, rest there, because when alternative construction is available, one has to consider which is the more commercially sensible. On this aspect of the matter, Mr. Zaccaroli has all the cards. And then at the bottom of 26, it says, in such circumstances, it's much more appropriate to adopt the more rather than the less commercial construction. And then at 30, Lord Clark goes on to say, in my opinion, Lord Justice Longmore has then neatly summarised the correct approach on the problem. That approach is now supported by a significant body of authority, as stated in a little more detail in 21 above. It's to ensure that where a term of a contract is open to more than one interpretation, it's generally appropriate to adopt the interpretation which is most consistent with business common sense. So that's Rainy Sky. Then turning to Britvic, which is in the other authorities bundle, and at tab 6, and Lord Justice Nuge's judgment, paragraph 70. And again, he refers, it's a reiteration and support for that proposition that is set out by Lord Clark in Rainy Sky, and then also just at G, where
Sorry, G where?
I'm at page 165. It's paragraph 70 of Britvic. It's Lord Justice Nuge's judgment.
I thought Nuge's judgment, but it's paragraph
70.
Thank you.
And we see in the middle, as I said, it's a sort of reaffirmament of those principles that I've just set out in Lord Clark, but also then it refers there to Lord Hodge, that there must be a basis in the words used in the factual matrix for identifying a rival meaning. And in my submission, there very much is a meaning, that the contention that I say applies here, certainly it is not stretching the language to the point of breaking point or anything of the sort for there to be a share sale to be to fall within clause 3. And then can I turn to Lewison, which is at the back of the second bundle. I'm going to just start with chapter 7, which is the canons.
Strictly speaking, I don't think Lord Justice Nuge is actually in the majority, is he, on this point? Because Lord Justice Coulson agreed with the Master of the Rolls.
Yes.
And the Master of the Rolls didn't at least say, as far as I can tell, that he agreed with. Sorry, he does. Sorry, I'll take that back. He agreed right at the very end of his judgment, so I'll take it back.
Yes. Thank you.
Sorry.
So chapter 7, Lewison, and in particular, the passages that start at 7.161. We see that.
I'm sorry, Lewison at page.
It's 784 of the authority.
Thank you. Sorry.
And this is the section, these are the canons of construction, and this is the section on the reasonableness of the result. Now, it might be, it starts off that the reasonableness of the result of any particular interpretation is a relevant consideration in choosing between rival interpretations. You'll see then at the bottom of that page at 7.161, there's a presumption that businessmen do not intend to do anything absurd, and we see that in that paragraph. It then goes on the next page. However, this approach goes further and might appear from the use of the words absurd and utterly fantastic. In the latter case, Lord Reed put the point more neutrally, saying the fact that a particular construction leads to a very unreasonable result must be a relevant consideration. The more unreasonable the result, the more unlikely it is that the parties can have intended it, and if they do intend it, the more necessary it is that they shall make that intention abundantly clear. We then see an Australian authority where Justice Gibbs, in the middle of that subparagraph below, if one can see where he begins, the court has no power to remake or amend a contract for the purpose of avoiding a result which is considered to be inconvenient or unjust. On the other hand, if the language is open to two constructions, that will be preferred which will avoid consequences which appear to be capricious, unreasonable, inconvenient or unjust, even though the construction adopted is not the most obvious or the most grammatically accurate. And then going over the page, I wonder if, and again, conscious of the time, 7.164, we see Lord Justice Longmore there, the passage that I've already referred to in Rainy Sky, and that was approved by the Supreme Court in Rainy Sky. And then Haywood and Norwich Union, Lord Justice Peter Gibson said it's always permissible to test whether words have a given meaning by considering whether they produce an unreasonable result. If they have that meaning, the more unreasonable the result, the less likely it is the parties intended the words to have that meaning. And then in a more recent, slightly more recent, I'm not sure it is, 2001, Lord Justice Mance in GAN Insurance and Taiping Insurance. It's the second half of that subparagraph where it starts, in my opinion, about checking, and so refer to that, and then over the page, Cargill International. And now, if we were dealing with absolutely crystal clear, plain words, then Mr. Knox's submissions on absurdity would have effect. But what I say here is that we don't get to that situation because we are dealing with rival interpretations of words, and that there is ambiguity here. But if there isn't ambiguity, and this court considered that the words are crystal clear, then in my submission, the appeal should still be allowed. And we see that at 7.167, where Lord Dyson said in Thompson and Goblin Hill Hotels, the plain and ordinary meaning of the words used can only be displaced if it produces a commercial absurdity. So even if these words are plain and ordinary, and this court can read them as such, then because it leads to such a commercially absurd result, in my submission, they could be displaced. So those are the passages in that section of Lewison. Just for the sake of completeness, Lewison also deals with this in the chapter 2 in the previous tab at 2.55 through to 2.53, where he starts, is absurdity a precondition? 2.53, and then one reads to 2.58. There's nothing that I've already said in there, and I would ask the court, though, to consider and look at those particular paragraphs of Lewison. So has something gone wrong with the language? Yes, it has. Can it be resolved through a process of interpretation? Yes, it can. Should it be? Should the principles that are applied be the principles that avoid absurdity? Absolutely. Should a commercial construction be adopted? Yes. And in my respectful submission, once one gets to that point, then in my submission, the clause 3 falls into place. What I do also say in response to, there is a final point, which is this point about bad faith. It is an artificial distinction that Mr. Knox seeks to draw between a sale in good faith and one in bad faith. There is, of course, in English law, it's whether there really is a clear concept of bad faith in any event, but it would create commercially immense difficulties that a client my client or JOP would have to start to allege bad faith, and the only way they could succeed on a sale, if there had been a sale by a company, would be in this very limited ground that one was able to show successfully that it was a bad faith transaction. It is an artifice there, and one that really is devoid of the commercial reality that we were dealing with in this particular situation. Again, in response to the point that JOP was gaining some significant benefit, you've seen from the points that I just made 10 minutes ago about the sale of Soto, there is nothing in this agreement that says that he doesn't get a payment, or his heirs don't get a payment in the event of a sale of Soto. The sale of Soto was always comprehended and contemplated, and that was going to take place, and thus we are dealing here where this was sold for over 20 million euro, where we're dealing with a situation that the significant value of the asset was the golf course, both in terms of the land and also the trademarks associated with it. The very minor aspect in terms of value was the surrounding plots, if those could be developed and sold at all. And of course, in practice, that actually didn't happen. There was no development at all. So this isn't a case where one can say, well, JOP did have a benefit and it's just bad luck that the sale ended up taking place through a share sale. The parties always knew that was the end result. The acquisition was through Soto, and the end result, the disposal, was going to be through Soto, because that was the only sensible way of doing that. I realise I actually got a few minutes left, but I don't plan to use that unless my lady and my lords have any questions arising from any of those points that I've just made.
If you would just, sorry.
I just wanted to draw attention to 7.168, which follows immediately on what my learned friend took me to endorse. I don't propose anything else. It's just what I call a qualification. 7.1, page 787. That's all. One might say that's the better grammar.
Thank you. If you will just give us a moment. Thank you very much. We were just discussing the framework of this going forwards. You'll recall and remember, I think, that we're sitting at 10 a.m. in the morning and until 4 p.m. If you hadn't recalled, that is how it is. And I'd be grateful if you could agree between you how to use that day most effectively to cover all of the remainder of the issues. And that's going to be quite a challenge, but that is something that needs to be addressed. Thank you very much indeed. 10 o'clock.